All right, we will call this meeting of the Tennessee State Board of Funeral Directors and Embalmers to order. It is now 10:14 on Tuesday, September 14th. Ms. Bohannon, would you call the roll?
Fred Berry.
Present.
Anthony Harris.
Present.
Tanya Haynes.
Present.
Clark McKinney.
Here.
Scotty Porsche.
Here.
Charles Rahm.
Here.
Robert Shackelford.
Here.
Mr. President, all board members are here and accounted for.
Thank you, Ms. Bohannon. Since we are having some who are attending virtually today, I would remind everyone that all of our votes will need to be by roll call. And I would also ask that if you make a motion or a second, if you would please identify yourself by name for the record. We will now entertain a motion to review and adopt today's agenda.
This is Fred. I'll make a motion to accept today's agenda.
This is Charles. I'll second.
I have a motion by Mr. Berry and a second by Mr. Rahm to review and adopt the agenda as presented today. Ms. Bohannon, would you call the roll, please?
Fred Berry.
Yes.
Anthony Harris.
Yes.
Tanya Haynes.
Yes.
Clark McKinney.
Yes.
Scotty Porsche.
Yes.
Charles Rahm.
Yes.
Robert Shackelford.
Yes.
Motion is passed for the agenda.
Thank you. Our next item of business is to review and approve the board meeting minutes for August 3rd, 2021, or to amend them as necessary.
This is Anthony. I make a motion we accept as presented.
This is Fred. Second.
We have a motion by Mr. Harris and a second by Mr. Berry to approve the minutes as they have been presented. Ms. Bohannon, would you call the roll, please?
Fred Berry.
Yes.
Anthony Harris.
Yes.
Tanya Haynes.
Yes.
Clark McKinney.
Yes.
Scotty Porsche.
Yes.
Charles Rahm.
Yes.
Robert Shackelford.
Yes.
Motion is passed for the minute.
Thank you, Ms. Bohannon. Mr. Glandorf, would you please present the legal report at this time?
Good morning, members. Good to see you all here. Tony Glandorf, I'm the Chief Counsel for the Regulatory Boards Division and the Funeral Board. If you pull up the legal report in front of you, I'll go through these one by one. And then I'll pause at the end of each so that I can entertain any questions that you all might have. So number one, I'll just read the number 21029521 against funeral director. Here, this is a consumer complaint that alleged unprofessional conduct. They allege that the respondent provided the complainant with a price list substantially higher than the average cost within the area, and that the respondent failed to provide the complainant with information he requested to transfer the body of his father to another funeral home about how that was to be done, and alleges that the respondent made errors on the death certificate of the deceased and caused extreme delays. The respondent did respond to this and indicated that the price list that was provided was for an affiliate location which has differing prices, that the respondent states that they did provide the complainant with information on how to transfer the complainant's father to another location, and that the respondents, they stated that upon notifications of errors on the death certificate that they immediately sent documentation required to facilitate that, and they denied all allegations of unprofessional conduct. So generally this complaint was sent for an investigation because it was surrounding a conversation that was had between the complainant and the respondent other than the death certificate. And after the interview by the field investigator and obtaining documentations, they didn't find any significant violations that we could actually show. And so our recommendation is a letter of warning in this matter.
did the investigator, this is Fred, did the investigator give any, or make any note of when we say extreme, how long was that?
Say that again, extreme.
Yeah, the delay in the death certificates, I think the wording was used extreme, but it's helpful to know exactly how long. It looks like the investigator would have made a note about the length of time that it actually took.
I don't have that in front of me. I can find that if that's helpful. I apologize.
No problem. It's just when, I guess, in these complaints, when they're talking about delays and things, it's just helpful to know really what the delay, how long the delay was. And extreme may characterize it correctly, and extreme may be an overstatement. But
Right. The word extreme was the complainant's. That was the complainant's statement that it caused extreme delays. Sorry.
This is Robert. Did the respondent give any reason as to why a general price list was provided from a different location other than the one with which the complainant had chosen to do business?
So the price list, the price list that the respondent gave the consumer was a price list for their establishment. The price list that the consumer is referring to was for an affiliate establishment, not at the location they were visiting. So their complaint was, well, the other establishment has a lower price. I should have these prices. They're not competitive, is what you're providing me. But the price list that they provided them was actually the prices of their location. Sorry if that was confusing. It's the difference between who said what when I wrote that up. I'll take note of that. I apologize.
So the price list presented was from the servicing location. They just have multiple locations, and they have some that have differing prices.
Yes, sir. Yes, sir.
Okay. Thank you for that clarification.
this is Fred. I'll make a motion to accept the letter of warning.
This is Clark. I'll second.
We have a motion by Mr. Berry and a second by Mr. McKinney to accept council's recommendation of a letter of warning. Ms. Bohannon, is there any other discussion before we call for the vote?
Mr. President, Anthony, one quick question. Do we have verification of a corrected death certificate after the amendment, or is that still hanging?
I don't have verification from the investigation that it was actually corrected. I would generally assume that that it would have been when the respondent said that they were correcting it.
Can we somehow, and this is just question, I don't know, Mr. Berry, if you want to do this, but can we in that recommendation ask that they present a copy of that when they get this letter of warning, just so that we can make sure it was all cleared?
There's no issue with my office being able to request that.
Based on number 3 there, the assumption is that it created long delays in the state, but it must have finally been amended and corrected for that. But I'll just amend the motion to note it, if the board could reach out and ensure that the death certificate was corrected.
Mr. McKinney, are you comfortable with that, with your second?
Yes, sir.
Very good.
Thank
Any
you.
further discussion? If not, Ms. Bohannon, would you please call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rom,
Yes.
Robert Shackelford.
Yes.
Mr. President, the motion passes.
Thank you.
Thank you. So number 2 and number 3 are put together on this one. They are numbers 2021-034-771 and 2021-034-761. And I'll generally say that the issue in this one is a funeral director that will not provide the quarterly report of apprenticeship training on an apprentice who quit the establishment. And so I'll go through this. The complaint was made by an ex-employee alleging unprofessional conduct by the respondent. They specifically stated that they were employed and serving as apprentice under the respondent's funeral establishment. They stated that the apprenticeship began in January 8, 2020, and they resigned from the establishment on March 8, 2021. They stated that March 16, 2021, they sent the respondent a letter requesting signatures for the certificate of completion of the apprenticeship, and for the January to March 2021 dates. And that with that quarterly report for training, the complaint states that the respondent received the mailings on April 5th, and since that time they haven't received any communication so that they can have that signed. The respondent responded back to us stating that that they did receive the documentation from the complainant, but they were unable to sign off on the documents because they did not complete the required apprenticeship hours. Essentially said that this person pretty much took off work for a month, and so they hadn't completed their hours. The respondent states that they don't have any valid documents to sign because they were never completed. So in order to help facilitate obtaining documentation, we sent our investigator out to speak with the funeral director to get clarification. And I requested I requested if they would be able to provide us with documentation that shows the hours that they did complete, which they were not open to. So my recommendation is authorization for, besides a formal hearing, a $250 civil penalty to be reduced to a letter of warning if they complete the actual certificate of completion of percentage of apprenticeship up until January 2021, and all outstanding quarterly reports for apprenticeship training given to the department. The issue we have is that if they refuse to provide the hours that they actually did complete, then we don't have any record from the apprentice, and the apprentice is required to send that to us. They can't do that if the funeral director does not fill out the form. So we're just asking the funeral director complete the form on the hours that they actually did complete and send that to us, so we have that record of the apprentice actual training.
This is Fred. It appears to me they could go back to payroll records and pull that information.
They did. They showed that to us. Absolutely, sir.
Okay.
And they can fill it out. They don't want to fill it out.
Right.
Because I believe because they didn't show up for work and they resigned that position, they indicated that they're not going to fill out any of that paperwork because they didn't meet the hour requirements. We understand that they probably did not meet the 40-hour-a-week requirement, but it's still a requirement that they send us what they did do. So the letter of warning is so that we can clarify to them that we need you to submit the hours that they actually did do, so that we have that as a record on the apprentice. Understanding they probably didn't meet the requirements of weekly, but to not provide them to us is really not acceptable at all, since we don't know how many they actually did.
This is Charles, motion to accept recommendation.
Second.
And we have a motion by Mr. Rahm, and who made the second?
Fred, sorry about that.
That's quite all right. Thank you, Mr. Berry. Is there any other discussion? If not, Ms. Bohannon, would you please call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rahm,
Yes.
Robert Shackelford.
Yes.
Motion passes.
Number 4 and number 5, they are both also related. One is a funeral director in Balmer, same person. Numbers 2021037061 and 2021037081. You have seen this set of facts previously at your last meeting. It's the same transaction or occurrence, same set of facts as what happened, different respondent at this time. And so this is the respondent I'll present to you that is the one who I would believe is more culpable to the actions, and we finally have this ready to present to you all. So this was a consumer complaint alleging unprofessional and unlicensed activity. The complainant was an attorney who's submitting on behalf of a brother-in-law of a decedent. The complaint states that the previously licensed funeral director, now not licensed, and previously licensed in Balmer, same. They contracted with the funeral home for services to include the shipment of decedent to the home country of Guatemala. However, that was never done. We did send this out for investigation, and during that investigation, we found that the owner of the funeral establishment was contacted by the respondent with an order to embalm the decedent and arrange for shipment to Guatemala. The respondent here, they said, surrendered all licenses in March of 2020, stemming for other similar type allegations. The body of the decedent was actually brought to this establishment August 5th of 2019. Arrangements were made to ship on August 22nd. The establishment, not the respondent here, but the establishment stated that they were informed by the respondent that the remains of the decedent were actually shipped on September 4, 2019. The respondent here, this funeral director and embalmer, was not available to confirm any of these statements. They will not speak with us. On or about March 6, 2020, the establishment stated in our investigation that a second funeral establishment contacted them and said that the remains of the decedent were at his funeral home, but had belonged to that first establishment. So they, unaware of this, that they were not aware that they had been transferred until that time, and they arranged for the decedent to be moved back to their establishment. They stated that they attempted to contact their brother-in-law to no avail, and also the Mexican consulate. Here I don't have an explanation as to why it's not the Guatemalan consulate, other than it could have been just confusion. And they reached out to the respondent, who would not cooperate with them. The establishment, due to decomposition of the remains, determined that this body would not be able to, the decedent would not be able to be moved out of the country, and without being able to communicate with the respondent with a clear understanding as who had right to disposition or power of attorney, they decided to bury the remains, and they paid for those services and the headstone for it. And the information, the plot was given to the respondent to provide to the family. So in this scenario, the respondent, from our analysis, is the person who's most culpable that the remains were never shipped out of country, and that they were essentially moved from one funeral establishment to another to hide the fact that they had not been shipped out of country. The remains were badly decomposed at the time. So this respondent has already surrendered their funeral embalmer license, which is something the board would not be able to remove anymore. However, you all still have the authorization to issue civil penalties because they were licensed at the time. And so our authorization is requesting for a $10,000 civil penalty via consent order or formal hearing.
This is Clark. I make a motion to accept council's recommendation.
This is Fred, second.
We have a motion by Mr. McKinney and a second by Mr. Berry to accept council's recommendation. Is there any further discussion? If not, Ms. Bohannon, would you please call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rahm,
Yes.
Robert Shackelford.
Yes.
Mr. President, this motion passes.
Thank you, Ms. Bohannon.
Number 6 is number 202103841 against a funeral establishment. This was an anonymous complaint that the department received, stating that the respondent, which is funeral establishment, received a Paycheck Protection Program loan. Despite not being a business, they stated that the respondent lied on their loan application, indicating that they had more than 4 employees. The respondent actually responded to the complaint and indicated that they are operating, had never been dissolved, which as a business, and that they indicated that they do have more than 4 employees on their staff. This is generally not something within the board's jurisdiction as the type of complaint. It is an anonymous complaint. My recommendation is closure on this matter.
This is Anthony. I make a motion we accept legal's recommendation.
This is Fred, I'll second it. This is Fred, I'll
Mr.
second
Shackelford,
that.
Robert's on mute.
you're muted, Mr. Shackelford.
Thank you, Ms. Bohannon. And we have a motion by Mr. Harris and a second by Mr. Berry to accept council's recommendation of closure. Is there any further discussion? If not, Ms. Bohannon, would you please call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Round,
Yes.
Robert Shackelford.
Yes.
Mr. President, this motion passes.
Thank you.
Number 7 is number 2021039-481 against the funeral director. This was a consumer complaint regarding unprofessional conduct regarding the refund of a prepaid funeral benefits. Without reading it further, to go down to the bottom, the consumer actually provided us with information saying that they had been refunded, and they indicated that all of the confusion and delay was their failure to update their phone number to provide to the respondent, and so they had been satisfied on this matter. So our recommendation was closure.
This is Clark. Motion to approve.
Anthony, second.
We have a motion by Mr. McKinney and a second by Mr. Harris to accept council's recommendation for closure. Is there any further discussion? If not, Ms. Bohannon, would you please call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Round,
Yes.
Robert Shackelford.
Yes.
Mr. President, this motion passes.
Thank you.
Number 8 is number 2021041-651. Here, this was a competitor complaint alleging unprofessional conduct against the funeral establishment. The complaint, they alleged that in January 2020, they provided funeral services for a family who believed they had a Westminster pre-need that was issued by the respondent. The complaint states that numerous phone calls were made inquiring about the policy and its value. The complaint states that they have the complaint states that they have since been advised to email one individual to leave a message for another, and to have the family write a letter, etc. This was multiple items, they said, in order to have the matter resolved. And as of date, the complainant says they've not heard back from the respondent. The respondent did respond back to this complaint, essentially didn't contest these issues. They did state that the individuals who the complainant was informed to contact are no longer employed by the respondent. The respondent apologized for not promptly responding and reminded their employees to do so going forward, and they've since found the records regarding the policy and reached out to the complainant establishment to discuss how they can claim the policy as payment. And the complainant did respond back that they were working with the respondent. Our recommendation for this authorization for a formal hearing and a civil penalty in amount of $1,000.
This is Clark. I'll make a motion to accept council's recommendation.
Charles, second.
We have a motion by Mr. McKinney and a second by Mr. Rahm to accept council's recommendation. Is there any further discussion? If not, Ms. Bohannon, would you please call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Round,
Yes.
Robert Shackelford.
Yes.
Mr. President, this motion passes.
Thank you.
Number 9 is number 2021046-821. Here, this is a consumer complaint alleging unprofessional conduct. The consumer states that their parents purchased 2 plots in 1997 from respondent. The consumer states that in 2016, 2 family members passed away, but to date, that their headstones have not been placed. The consumer states that they have spoken to multiple staff members who have been unable to assist them. The consumer further states that the entire process was stressful for them. The respondent's representative responded to the complaint indicating that the family had not reached out to design the markers until June 2021. The representative indicated the respondent staff has met with the family. They have not yet received the rendering from the vendor and is following up on the status. They indicated that once the respondent receives rendering, they will send it to the family for review and approve. Due to the history of this funeral establishment of similar type actions of not responding back to the family and not addressing these issues timely, my recommendation is authorization for a civil penalty in the amount of $1,000 and for a formal hearing if necessary.
This is Charles, motion to approve.
Anthony, second.
We have a motion by Mr. Rahm and a second by Mr. Harris to approve council's recommendation. Is there any further discussion? If not, Ms. Bohannon, please call the roll.
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rahm,
Yes.
Robert Shackelford.
Yes,
Mr. President, this motion passes.
thank you.
Thank you. I believe that we are now on number 11? 10. I apologize. I started to scroll back and forth. Thank you. Thank you.
Yeah, number 10.
2021 0476 31. And I wanted to preface this with number 10 is, I think it's the same respondent as was in number 8. For some reference there. Normally I would put them together, apologies. So this is a consumer complaint alleging unprofessional conduct. They stated that on April 30th, 2021, their mother passed away and was not picked up until May 1st. After multiple calls, the respondent, after multiple calls to the respondent from the hospice nurse, the consumer states that they attempted to get in contact multiple times leading up to the service for May 10th, but the respondent was unresponsive. The consumer states that they were informed that their mother's remains was being held by another establishment, not the respondents, and the consumer states that their mother's remains arrived 45 minutes after the visitation service actually began. The respondent did respond to the complaint. They indicated that the delay in the removal service was due to a third-party removal company that respondent will no longer be doing business with, that the respondent has implemented new procedures to prevent delays of visitations, and they're working on hiring additional staff to ensure all inequities and requests are answered timely. In reviewing this, it didn't appear that there was anything that occurred that the respondent could not have avoided themselves, that they may be more attentive, and based on that, for those 3 violations, our recommendation is authorization for $3,000 civil penalty and for a formal hearing in conjunction with, if you see their history that they had in basically 10 and number 8.
This is Robert. The other establishment that was mentioned where the body was being held, was that an affiliate of the servicing establishment, or was it the third-party removal service company?
Mr. Shackelford, I'm not sure about that. I apologize. I don't have that specific fact whether or not it was one of their affiliates or the actual third, the removal service location. I cannot remember that. I apologize, but I can find that if that's necessary.
This is Fred. I'll make a motion to accept recommendation.
This is Clark. I'll second.
Okay, we have a motion by Mr. Berry and a second by Mr. McKinney to accept council's recommendation. Is there any further discussion? Mr. Glandorf, just a question, and don't know if you can give a definitive answer on this or not, but this establishment is compiling quite a history with the board in a very short order. Do you feel like there are any other more punitive actions that should be taken other than the monetary fines and the authorizations for formal hearing regarding their licensure? Or?
Mr. Shackford, I think I wouldn't have a recommendation at this time for any more punitive measures against them at this time. I will say because of this, because I am monitoring it. I know that Mr. Gribble is also monitoring. We are in communication with this respondent, and not just the location, but their senior management that manages all of their affiliate locations. They are aware of the situation. They are responsive to us about these issues that we do raise. I will say that it is a concern that these issues are still coming up, even though we're speaking with them. But I think that's something that I can't give a recommendation on right now. I know that is something that I will I will look into. I will let you. I may be able to make a recommendation or give more information at the next meeting, but as of right now, I wouldn't have a recommendation on that.
Mr. Glandorf, do you know if the same manager has been present at that location throughout this recent flurry of complaints, or has it been a different manager?
Backford, Mr. Glandorf asked me to speak to that. Of course, these complaints were filed back earlier this year, so there's been many different managers, or a multitude of managers, and then there was manager that recently changed as well. So there's not been any long-term continuity with any manager. However, there are 2 funeral directors that have been there for many years, and I know that's the stability to it. And as Mr. Glandorf said, we're still in consistent communication with senior management of the corporation, and they're aware of concerns, and I'll let him speak to. To answer your question, the manager has consistently changed. The one that's there now has only been there 2 weeks or so. The one before that was probably there 8 weeks, maybe 10 weeks, something like that. And the one before that, asking Mr. Glandorf a question. The manager before that was the complainant for the severe unprofessional conduct, and so he left. He had been there probably a couple years or so, at least over a year, I know. So that kind of gives you the past history for the last 18 months, 2 years. They tell us that they have a general manager, and we've cautioned them about using the term general manager when he's not licensed in Tennessee, that is there now, but they have a Tennessee licensed funeral director named as the manager, and this quote-unquote general manager was previously licensed in Tennessee, and I've spoken with him directly about how to get relicensed, and that was back 3 weeks or so ago, 2 or 3 weeks. So we've given them information. We've tried to work with them, but also inform them of statutes and rules and expectations.
Thank you, Mr. Gribble. Is there any further discussion? If not, Ms. Bohannon, would you please call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rahm,
Yes.
Robert Shackelford.
Yes,
Mr. President's motion passes.
thank you.
Number 11 is number 2021048911. Here, this is a consumer complaint that alleged unprofessional conduct. Specifically, they allege that the respondent had failed to provide a price information on the telephone required under the funeral rule, that the respondent failed to inform the son of the deceased as to how to obtain a certificate of death, and that they failed to treat a member of the public in a respectful manner, which is the complaint. The response was submitted by the respondent's attorney, who indicated that they were not obligated to provide copies of their death certificates to persons other than who had the contractual relationship with the respondent, and they indicated that they denied the allegation that they were requested a price list over the phone, and the consumer responded rebuttal indicating that respondent refused to provide a price list, and that further that the death certificate has false information on it, and the individual contracted the respondent lied about their relationship with the deceased. Essentially, that the person who they contracted with is not who they say they are on the death certificate. Our authorization, our recommendation regarding their interaction with the consumer is authorization for a $500 civil penalty, along with for authorization for a formal hearing. I will say that when we have responses by attorneys, it's extremely difficult to get any detail as to the interactions with the respondent, because obviously they weren't there. So with that, we have to take into consideration the facts that the complainant gave us as opposed to the facts that the respondent responded back to us.
This is Anthony. I'll make a motion. We accept legal's recommendation.
We have a motion by Mr. Harris. Do we have a second?
Scotty, I second.
We have a second by Mr. Porch. Is there any further discussion?
Just one question that I have. This is Fred. At what point would you actually, or what triggers the response of sending an investigator to get more, try to determine more of the details and facts of the situation? Because there's some things that seem to be missing. But
the issue is that I can't talk to the respondent at that point in time. I, as an attorney, can't. Once they get an attorney, I have to speak with the attorney, and I have to go with the facts that the attorney give me, and I have to ask more questions about that. And then they go back to to their client, and they get those facts. So every time you get an attorney involved in a response, it's extremely difficult to get those facts. So to your question, I'm usually reluctant to send an investigator out to go speak with the attorney, just based on my historical knowledge of the type of information that we get back. We usually don't get sufficient information back as to the details on that. If you would like me to, I absolutely can. I absolutely would do that on this one, if you would like me to.
Yes, I'd ask the other board members your thoughts on if you feel like the details need to be cleared up a little bit on this, or, I mean, there are some points as far as if the funeral director was lied to as to the relationship, that becomes a factor. Who's entitled to receive the death certificates, and the funeral home having to provide the death certificates does somewhat relate to who the contract's with, and what is the relationship of the other individual. Of course, that individual could go to the health department, and if they prove their relationship, they could get that death certificate. So I just asked the other board members your thoughts on that before we vote.
Fred, I agree with you. There's some cloudiness here about the whole situation.
So it would be possible, of course, we've got a motion in a second, but is it possible to delay the action on this to see if we can find out just some more details? And can an investigator go to the establishment and ask to see records? Or
I would have to go through the attorney at this point in time. Once they do that, I'm not, my office cannot do that as an attorney, because my office requests all the investigations so that they are attorney work product, and it wouldn't be able to do that. I will point out that number 2, if you look at it, number 2, the complainant said that they requested the respondent, and they asked the question as to how they obtain a death certificate, and they wouldn't tell them how they obtain a death certificate, not to give it to them, but how to obtain it. And then the response from the respondent is they're not required to provide one to this person, but that wasn't their question. They just asked, how would I get a copy of the death certificate of this person who came through your funeral establishment? And they wouldn't inform them as to that. To your point of, you can go down, you can go to this office and obtain one, and that probably would have clarified a lot of the issues that we're seeing right here, because they wouldn't be responsive to them, which is hence why we get to the $500 civil penalty for the interaction between the respondent and this consumer.
And plus, they have a history with death certificates, it seems like.
That's all I have.
Any further questions or thoughts by the other board members?
Fred, I'm okay to amend my motion if I'm understanding and I'm agreeing with you, to delay this if we can get some more clarification on who the original informant was. Is that sort of what I'm understanding?
Correct. Just the issue of, it sounds like the thing kind of got sideways, but if be nice to know exactly what were the next of kin, who was the next of kin on this deceased, was there multiple next of kin, and just how that interaction occurred. But I guess what counsel is telling us is that all we could do would be to ask those questions to the attorney. An investigator would not be able to go and ask the manager those questions or the firm. But unfortunately, if the respondent had I guess would have been more detailed and clarified this, then that would have helped them. So in this situation, their lack of clarity and details may lead to the civil penalty. So I'm okay with the motion as is.
Okay.
I'm
All
fine
right.
with it.
Any further discussion? If not, Ms. Bohannon, would you call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rahm,
Yes.
Robert Shackelford.
Yes.
Motion passes.
Thank you.
Number 12 is number 2021049471 against funeral establishment. The summary is, the question is who's who in relation to the deceased. This was a consumer complaint alleging unprofessional conduct. The complaint alleges that their father passed away in April 2021, and since the consumer is the complainant is the oldest sibling, they were under the impression they would be the next of kin. They stated that they were informed by their half-brother that he would be arranging and paying for services. Consumer states that they reached out to the respondent, who was unable to provide information about the arrangements, and that they were rude to this complainant. The consumer indicated that they eventually found out that a coworker was arranging the services and was identified on their death certificate as an actual daughter. The consumer states that they were informed by the respondent that the coworker had a power of attorney, so they did not pursue the issue any further. The respondent responded to the complaint, indicated that the respondent entered into a contract for the services with an individual who indicated that they were the daughter of the deceased. The individual provided a durable power of attorney and was listed as the daughter in the obituary. The respondent they state that they acted in compliance with the rules, and they denied all other any other allegations, and they provided supporting documentation as such. So in this scenario, though the complaint appears that there's a confusion as to next of kin or who is a sibling of the deceased, the respondent did provide us with a durable power of attorney, which is what we would review for the actual who was the next of kin with right disposition. As such, our recommendation would be closure.
This is Clark. I'll make a motion to approve council's recommendation.
Anthony, I'll second.
We have a motion by Mr. McKinney and a second by Mr. Harris to accept council's recommendation of closure. Is there any further discussion? If not, Ms. Bohannon, please call the roll.
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rahm,
Yes.
Robert Shackelford.
Yes.
Mr. President, the motion passes.
Thank you.
Number 13 is number 2021050391 Here, this is a consumer complaint alleging unprofessional conduct. They stated that they contracted and paid the respondent for cremation services of their father. They stated the respondent sent they alleged that the respondent sent some of the cremains to the decedent's daughter without authorization. And they state that they've requested to speak with the respondent but have not heard back as of the date of the complaint. The respondent responded indicating the following: that research of the staff of their records showed that the cremated remains were given to the consumer and no one else. That the daughter, who the consumer indicates received some of the cremains, they were never shipped any cremains from the respondent. That the daughter was actually contacted but indicated that they did not want to speak about the matter. The respondent has requested on 3 different occasions for the consumer to bring the cremains back to the establishment. They will verify that they are the cremains of the father, but the consumer refuses. And the respondent has provided documentation providing that no such incident occurs. As such, I recommend closure of this matter. It appears I don't see that the respondent can do anything else in this situation, that the consumer is just unsatisfied.
This is Fred. I move that we accept council's recommendation of closure.
Charles, second.
We have a motion by Mr. Berry and a second by Mr. Rahm to accept council's recommendation of closure. Is there any further discussion? If not, Ms. Bohannon, please call the roll.
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porch,
Yes.
Charles Rahm,
Yes.
Robert Shackelford.
Yes.
Mr. President, the motion passes.
Thank you.
Number 14 is number 202105231 against funeral director. This is a consumer complaint alleging unprofessional conduct. They state that their mother passed away in April 30th, 2021. As of the date of June 25th, they had not received a death certificate. The consumer stated that their father passed away on May 20th and they received that death certificate, however, had multiple errors. The consumer states that the respondent has been unresponsive to their calls. The consumer also indicated that the respondent is letting their apprentices deal with families, I'm going to assume unsupervised. The respondent responded to the complaint indicating that they denied all the allegations and that they've been unresponsive. They stated that they did not personally handle the death certificates. However, the consumer's mother's death certificate is available currently for pickup and that the respondent will ensure the consumer's father's death certificate is corrected as quickly as possible. Lastly, the respondent indicated that their apprentices are always under the supervision of the licensed funeral director. Given the situation here, our recommendation is a letter of warning.
This is Anthony. I'll make a motion we accept the letter of warning, but I'd also ask that the respondent have to show the corrected death certificate to clear this case.
Charles, second.
We have a motion by Mr. Harris and a second by Mr. Rahm to accept council's recommendation of a letter of warning with the stipulations provided in the motion. Is there any further discussion? If not, Ms. Bohannon, please call the roll.
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porch,
Yes.
Charles Rahm,
Yes.
Robert Shackelford.
Yes.
Mr. President, the motion passes.
Thank you. And thank you, Mr. Glandor, for your report today.
Thank you, members, and Mr. President, if I could add, I just wanted to address the board and let you all know that our office is diligently trying to hire a replacement for this board as your attorney. We have someone that we have identified that has accepted a position within the department that I hope to be able to introduce you all at the next meeting. They will be under my supervision going forward of the legal reports and everything that they do until I feel comfortable that they could do it on their own. But I do appreciate your all's patience with me in this, and then the confidence that you've placed in me to move you all forward. I know from time to time over the years I've had to step in as the attorney for the legal reports and whatnot, and I know that does create some volatility within the program areas and who you see month to month. But I do appreciate your patience and you all working with my office on that. And I hope to be able to introduce you next month to that person.
Thank you for that update, Mr. Glandorf, and we certainly appreciate your service to our board. Next item on the agenda is the Executive Director's report. Mr. Gribble.
Good morning, board members. The first is the establishment license report and the individual license report. These are a report of license administratively approved by the Executive Director pursuant to board authority for the period of August 1, 2021 through August 31, 2021, and you have a list of those there in front of you. Next, closed establishment report. We do not have any establishments reporting closed since the last board meeting. Next is a disciplinary action report for this meeting, and it's a report of consent orders that have been administratively accepted and approved by the Executive Director pursuant to board authority and as reported on the July 21 Regulatory Board's disciplinary action report. And you have a list of those there in front of you as well. And one of the board members had asked me a question about this, and I want to make sure that the board understands that I never set the amount, that all these cases have been presented to the board by legal with a determination made by the board as to what the amount of the civil penalty or any other additional remedies that come before the board. When I say it's a report of consent orders that have been administratively accepted, what the board has given me authority to just to sign off saying that we accept it so that legal can close the case. It's but every complaint that involves a civil penalty is brought before the board, and even those complaints that don't involve civil penalties. Mr. Glandorf could address this, but occasionally, and I'm talking about maybe once a year, there's a complaint filed where the board absolutely has no jurisdiction or where there's obviously no violation whatsoever, and legal and works with the centralized complaints, and some of those may be closed, but a letter is sent to the complainant regarding those. But anything that has to do with punitive damages, that's decided by the board. I just want to clarify that because there's probably some questions maybe in other people's mind as well. The complaint report for today, we have 35 complaints that are open. 14 of those are against funeral directors and or embalmers, and 21 against establishments. That concludes my report. I'll be glad to answer questions if you have questions about these matters or any other matter.
Charles, motion to accept the report.
Fred, second.
We have a motion by Mr. Rahm and a second by Mr. Berry to accept the Executive Director's report as presented. Is there any other question for Mr. Gribble? If not, Ms. Bohannon, please call the roll.
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rahm,
Yes.
Robert Shackelford.
Yes.
Mr. President, the director's report has been accepted.
Thank you, Ms. Bohannon. I don't believe we have any individual or establishment license applications to review today, so we'll move to new business. And Mr. Glandorf, we'll ask you to take the stage again and guide us in our discussions regarding the rulemaking.
Thank you, Mr. Chairman. I will. I think this is going to be an easy morning on rules. There's nothing in here that we haven't either seen before or we're just required to do, so that makes it a little bit easier to review. If you look on the first page or the first 3 or 4 pages under the rulemaking discussion, you will see that we have in there public chapter number 549 from this last session, which became effective in May 2021. If you look on page 3, at the top of page 3, under section 14, there's a red arrow, and I would like to draw your attention to that. This is this public chapter right here made an amendment to the requirement of hours of apprentices, which amended it from a 40-hour week to 32 hours by statute. So that's so that was signed this past session. And if you go, if you direct over to the next few pages, you will see that I have made amendments, recommended amendments to Rule 0660-05-.01 that just amends those 40 hours references to the 32 hours that has been established now under the statutory scheme. Is that clear to everybody there? Do you all see that? So all we're doing there is we're just going to make the rule mirror the statutory requirement. That's just I just call that a cleanup because obviously we're going to go by the statutory scheme now. So that's on that first page there, which was 7 of 11 on mine. If you turn over to page 8, I'll preface these recommended changes to professional conduct with this, is that several years ago, this board already approved these recommended professional conduct changes. I believe it was 2018? 2018. Those were approved by the board, and they went to when they went to the Joint Government Operations Committee. There was one provision of those rules that was a point of contention for the committee, which was the language on page 9 regarding licensees who are found to have sexual misconduct with dead human body, that their license may be revoked by the board. It was the word may that I believe was the hang-up on that. And so I believe the end result was that this set of rules was not recommended for approval to go into legislation at the end of the year, which would make them permanent. And as such, they pretty much, I'll just say, they died on the vine. The end result is that one provision was the provision there in green is what the point of contention was, but because the entire set of rules was not recommended for approval, then everything else that the board had worked on and recommended was also not recommended for approval, and so it did not become a rule. I was there at that meeting, and there wasn't any contention over those these other professional conduct rules. So, as such, it's been an item that we knew to bring back up with the board to move forward on, and the recommendation in this context is to go ahead and take out on page 9 that green struck out language of H, which was a point of contention at the Government Operations Committee, and because we believe that it is now going to be addressed, if you move to page 10 by public chapter number 402, which also became effective this past session, where if you look down on section 2, it states that the Tennessee Criminal Code was amended to create to include within this area of violations under this April's law is anybody who engages in sexual contact with a corpse. And so there's generally been a criminal violation for any of this conduct. It is now very specific as to what it is, and so because it's very specific in the criminal code, I don't think it's necessary under my legal analysis that it be very specific that we may revoke a license for this conduct within the rules, because we can always go back and say, one, it's unprofessional conduct, and then two, you would have been, if you're convicted of this crime, then obviously it would be a violation of the board's behavioral rules that we could revoke a license of. So I say all that to say is I don't think that green highlighted H on page 9 is necessary to go into the rules packet, that there's other sufficient ways that we could discipline a licensee for that type of conduct. And if you all agree with taking that out, then we could go back and have a further discussion about the professional conduct rule amended changes, which is really providing a lot of clarity into the rules. Does anybody have any questions about that? I know I spoke for a while there.
Clarify, you would need a motion from the board to...
Not yet, but at some point.
Some.
Yes, sir. So if you all, or if there's no questions about why I would want to take that out of H, that green on page 9, then I could back up to page 8 and go over the blue highlights there, which are the actual changes to the rule. That, like I said, you have already approved it back in 2018, but if you all approve this today, then I would essentially schedule this for a future rulemaking hearing where the board would, at a public hearing, adopt these changes, and to allow the public to comment on it. So if you look back on page 8, if we go to 1A, we're indicating language here that members of the public would be treated with a respectful, reasonable manner. And then we say that unreasonable treatment is conducted that it falls below a standard of care. And then we list these as abusive, aggressive, and hostile, disrespectful conduct, or being unresponsive to the members of the public at such time without justification. And then we say, such as not returning phone calls, not answering inquiries, or leaving a member of the public unattended. So there's a little bit of expansion of some of these activities that we generally see from time to time, and we're illustrating those here in the rules. If you go down to C, as part of that, we indicate that if a particular funeral establishment has custody of decedent's remains, but is not selected and is vested under this right, under 703, the rights for disposition, to control the disposition of the remains, they must release those remains to the establishment properly selected, regardless of whether cost of any merchandise or services provided, and that such costs shall remain payable, and that failure to pay upon lawful demand may result in disciplinary conduct to the board. And then we say nothing herein should be construed to affect any civil liability. For those of you who may have remembered the discussion 3 years ago, there was a statutory change on the funeral board about the requirement of releasing remains from one establishment to another, even though the previous establishment had conducted services, that they shall be payable by the other establishment. Essentially made the second establishment is the one that is now responsible to be payable, so that the first establishment doesn't have to go back and deal with the consumer or whatnot on that necessarily, that it can be the second establishment for that. So this buttresses kind of into that legislative change, so that it's within the rules there for those costs. And again, we've already gone through these several years ago. I just wanted to go over them again with the board members and see if there's any thoughts of changes or additions or whatnot. But and then we go down to the blue E, which would now be a D, and we make some minor changes there to show that a licensee receiving any notice from the funeral board requesting a response, including but not limited to notice that a complaint's been opened, shall respond at a specific time, that they have to provide a response back to us. So this is really an administrative change that we'd like to make, because most of our inquiries to funeral directors nowadays may be by email and not by letter or certified mail. Through the COVID pandemic, certified mail has really been a difficult thing to receive responses back on with green cards and whatnot. But we do get a lot of responses back by email, and so we want to be able to say that if we email you a question, you have to respond back to us. You don't have to wait. I don't want someone. It's not beneficial to have the funeral director say, "Well, you didn't send it to me certified mail, so I'm not going to respond back to you." If we know we sent them an email, and we can confirm that they received it, we should be able to say that they have to give us a response back. And so that would be buttressed here under professional conduct. If you look at E, we're just adding that no unreasonable delay of filing a death certificate. That should not just be the responsibility of the establishment. We should also be able to look at the funeral director and embalmer who actually did it. So I think we would generally say we would look at the funeral director, but the rule actually looks at the funeral establishment. So we would just extend that also to the funeral director or embalmer, whoever is the one doing that. Lastly, if you look at page 9 under G, we have added in there two paragraphs under J and K. which indicates that a licensee or registrant shall not engage in any conduct that may mislead or deceive the public as to the physical location of any funeral establishment, which is where they're actually located at. And then K is regarding that they shall conduct themselves, embalmers, funeral directors, in a way that does not offend the reasonable sensibilities of the public and reflects respect for dead human bodies. So again, these had already been items of discussion a few years ago with the board, and I think now we can remove that H, which was a point of contention based on the statutory changes in the criminal code from this past session, and also our unprofessional conduct rules that we currently have. Does anybody have any questions about that I could entertain or clarify for you all?
So, Mr. Glandorf, the motion today would be to accept the rulemaking language as it has been presented to us and discussed, and then to grant you the authority to move forward with the rulemaking hearing. Is that correct?
That is correct, Mr. Chairman.
This is Fred. I'll make that motion.
I'll second. This is Clark.
We have a motion by Mr. Berry and a second by Mr. McKinney to accept the rulemaking language as has been discussed in our meeting today, and to grant the authority to Mr. Glandorf and his legal team to move forward with a rulemaking hearing. Is there any further discussion or any more questions for Mr. Glandorf regarding this proposal? If not, Ms. Bohannon, would you please call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rahm,
Yes.
Robert Shackelford.
Yes.
Mr. President, this motion passes.
Thank you, Ms. Bohannon. Our next item under new business are the remaining board meeting dates for 2021. At our last meeting, Mr. Harris had made the suggestion that we consider delaying our October meeting to coincide with the National Funeral Directors Association Convention to be held in Nashville this year, and Mr. Gribble would not be able to meet on a normal Tuesday, the 19th, and we had talked about perhaps Wednesday, October, and Mr. Gribble, I would assume that might also entail basically canceling our November meeting. Since it's scheduled for November the 9th, it would be in close proximity, so I'm assuming we might roll those two meetings into one. Would that be an accurate assumption, assuming that nothing major comes up to be discussed?
That's correct, Mr. President. If the board would consider this, I would suggest that you might consider a meeting on October the 20th and December the 14th. I did check to make sure this room is available, and it is, and we have temporarily reserved it, so we do have that on standby if we need it for those two dates. And then at the same time, I would ask that you cancel the October 12th and November 9th meeting. That way we can take them off the calendar, and it won't be confusing to anyone who might be needing to submit an application, an individual or establishment that would need to appear before the board. That way they'll have a clear understanding of what the remaining meetings are of the year, if that's what the board decides.
Are there any further thoughts from any of the board members regarding these proposed changes to our meeting dates?
Very possible that I would not be able to attend in person on the 20th meeting due to staff being out here in Nashville. Is it possible to do it remotely?
I think, Mr. Rahm, unless we get further instructions or different instructions, you could participate on October the 20th as Mr. Harris and Mr. Shackelford have participated today if you're available to do that at that time.
This is Fred. I'll make a motion to accept these revisions in our meeting dates and the cancellations.
This is Anthony. I'll second.
We have a motion by Mr. Berry and a second by Mr. Harris to accept the proposed changes to our meeting dates in October, November. Is there any further discussion? If not, Ms. Bohannon, please call the roll.
Fred Berry,
Aye.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rom,
Yes.
Robert Shackelford.
Yes.
Mr. President, the motion passes.
Thank you, Ms. Bohannon. Is there any other business that needs to be brought before the board today?
Mr. President, this is Anthony. Quick question. I know a couple of us have talked about this. Is there a possibility establishments that have applied for new licensure? I know we can't do this with new licensees because it would take us forever, but we do make a lot of decisions against establishments. And me personally, I would like to see the new establishments appear before us so we can get to know these folks. Just my opinion and a question to everybody else, if your thoughts on that.
Thank you, Mr. Harris. I, for one, would concur with that. I think that's an excellent suggestion. Do we have thoughts from other board members about that matter?
Fred, I would agree. I guess most of them do. They don't. Okay.
Can I possibly put that into a motion? Is that what we need, or what's our thoughts?
Mr. Glandorf, do you have any suggestions there regarding the board's legal action?
I think that's that process is set up by the administration, not necessarily through our legal office. So, I would just say that I think the preference is so that we can more quickly process applications that come in without any unreasonable delay. I think that would probably be my understanding is what the departmental policy would be.
I personally think it would cause a backlog myself. I think the method that it takes place now is a good one.
President, may I speak just a little bit and explain how the process goes?
Certainly.
If there's any question about any establishment initial application meeting the legal requirements, then obviously I consult with legal. And then if legal says there's a problem, then all those applications, whether it's an individual or an establishment, automatically come to the board now. The only ones that I administratively approve are the ones that where you can make the check marks and see that. And legal can speak to this, but at the end of the day, if they met all the statutory requirements and all the rules of the board, then it just helps to them to get in business faster. And usually by that time, I realize there are a lot of establishments now that are not maybe spending $1 million to $2 million on the brick and mortar building, but there are still establishments that are. And usually they want those licenses as soon as they can get them, because there are financial reasons that they need those. Now, back many years ago, every applicant, whether it was an individual or an establishment, appeared before the board at a board meeting, and those were all came personally before the board at that time. But I assure you that if there's any doubt whatsoever about an applicant, that application is sent to the board and reviewed by the board and either approved or denied by the board.
Thank you, Mr. Gribble, for that information. Mr. Harris, I might offer a suggestion as a compromise. I do agree with you. I think it's good that the board has an opportunity to meet these individuals who will be administratively involved in these establishments, and also I think to meet individuals. I think it's good for them to meet the board members as well. So what would the board think about the idea of allowing the license application process to continue as it is now, but to extend an invitation to those individuals whose licenses are granted to appear before the board at some point in the future, just to have the opportunity to meet them and for them to meet the board and ask us any questions they might have and to just get to know them better. What would you think about that as an alternative?
This is Anthony, and I totally support that and agree with that. Mr. Gribble, I also want you to know it's not that we don't, or I personally don't trust what you're doing, because I totally do. It's just, I'm like President just said, I think we're making a lot of decisions on establishments, and I would just love to get to know these people better.
Do any other board members have any thoughts about that?
This is Clark, having been here a while, a time or two. I definitely see both sides of it. I understand, once upon a time when I had an application for an establishment, I wasn't given a choice. I had to appear, and so I kind of like that. What I got to do, everybody else ought to have to do too. But I also see the other side of it. We don't want to unreasonably delay anybody, so I guess I'm sort of in the middle. But I would ask Mr. Gribble a question about when an establishment are they given the opportunity to come, or do you just tell them, I've approved this and you don't have to come? Or what kind of how do you handle that on the establishment applications?
We don't encourage them to come or discourage them from coming. I mean, I haven't talked to one yet that didn't want their license as soon as possible. Now, something that I would remind us all of, too, that I thought of while we were talking about this, and I completely understand, Mr. Harrison, whatever the board decides, we'll certainly be able to be glad to do administratively, as long as it doesn't conflict with the department's. I may have to check with the department's policies to make sure that whatever the board decides doesn't conflict with that. But a licensee can obtain 1 hour of CE for coming to a board meeting, for attending a board meeting. And I would submit to you that they could do that virtually as well as physically appearing. So that's in place when the rules that Mr. Glandolf talked about that the board approved in 2018. Then that was one of the rules that went through and went on through, because there wasn't any question about that. And so they can obtain 1 hour of CE for attending a board meeting. I understand your concerns. What we would hear in the office was, these, and of course now maybe they could appear virtually. I don't know whether you want them to personally appear or virtually appear, but if they appear personally, then they have if they're further than 75 miles from Nashville, they may or may not decide to spend the night. So they're going from their, even though they don't have a business to work at yet, they're probably doing other things to get that business ready to go. So they're going from home, a period of time. They incur hotel and motel expenses. And in Nashville now, I think the state rate is, I'd have to ask Ms. Bohannon, but it's in excess of $200 that, even the state rate. So hotels are not inexpensive. And that was the ideal at the time, was to, if they meet all the legal requirements, if they have done all the things that they need to do, then it'd be administratively reviewed and approved. Now, I communicate to them by email when there's approval and send a copy of the license. And I could certainly add to that, we would encourage you to attend the board meeting, and I could work with legal to come up with some, a paragraph there that we could put in that to encourage individuals and establishments to in the board meeting, either virtually or in person, and become more familiar with the board and the board's rules and the processes of the board, and let the board get to know the individuals better.
And that is another thing. If somebody's coming from Elizabethton, or they're coming from Covington or somewhere like that, Tiptonville, that's a pretty good haul to come into Nashville, and they're going to have to spend the night more than likely. So I'm assuming, yes, that was part of this, why these things were handled this way in the past. Part of the reason.
I would not have any problem at all with somebody that would like to attend virtually to save on that travel time and expense. And I think certainly that would be acceptable. And obviously it's not a requirement for licensure. If we continue with the process as it is now, we do not make that a requirement for licensure, but it's just an invitation that we could extend for someone to attend a meeting either virtually or in person, and allow us to get to know them and them to know us and ask us any questions that they might have of the board. But again, that's just a suggestion.
I totally support that thought right there. I think there needs to be another tool for us to get to know a little bit better about our new establishments and people that we're just making decisions on each month, and vice versa, them get to know us.
But would the board be comfortable with giving Mr. Gribble the authority to talk to our legal department and find out how best to handle that invitation and the proper wording, and they can report back to us at our October meeting?
Yes.
Okay. I don't know that we need a motion to that effect, since it's not anything that's going to be a requirement for licensure. So, Mr. Gribble, are you comfortable just in talking with the legal department and coming up with the best way to handle that invitation process?
Yes, we'll be glad to consult and follow back up with you at the next board meeting. We sure will.
Thank you. I appreciate that suggestion, Mr. Harris.
Thank you.
Are there any other items that need to be brought before the board today? If not, we will entertain a motion to adjourn.
So move.
Anthony.
Second.
We have a motion by Mr. Harris, and the second, was that Mr. McKinney?
Yes, sir.
All right. Ms. Bohannon, would you call the roll?
Ray Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rom,
No.
Yes.
There's always one in every group.
okay, Charles Rom,
Yes.
Robert Shackelford.
Yes.
Motion to adjourn has been approved.
Very good. We stand adjourned at 11:37. Thank you for your participation today, and hope everybody has a great remainder of the week. We'll look forward to being with you in October.
Thank you.
This meeting is no longer being recorded.